What is the definition of IP, or how would you define IP? This video is going to give you the answers to all of that and even tell you about the 4 types of IP. If you're new here, my name is Dylan Adams. I am a patent attorney and author of the best-selling book, Patents Demystified, which is an insider's guide to protecting ideas and inventions used by inventors, entrepreneurs, and startups worldwide, including at top universities like Harvard, Stanford, and MIT. You might also recognize me from my appearance on CNBC's hit show, The Profit with Marcus Lemonis. So IP, how would you define IP? What is the definition of IP? So let's sort of differentiate intellectual property versus real property. So real property is physical things like real estate, whereas IP or intellectual property relates to inventions of the mind, things that are created. Now there are 4 types of IP or intellectual property. There are trademarks, there are copyrights, there are patents, and there are trade secrets. So let's start with trade secrets. So trade secrets relate to things that are kept secret. And they can really apply to all sorts of intellectual property, especially at the beginning, and we'll kind of get into that later on. So trade secrets are things that are not readily known to the public, things that you can't, things that you can't search and find, things that are actually secrets, and things that have value. That's sort of the general definition of trade secrets. And you have to take reasonable steps to keep things secret. So you can't say, well, this is a trade secret, but then do it publicly, in a factory in a window. Like if you have a process that you want to keep as a trade secret, you can't have people walking by and be able to have them see what that is. So it has to be something that you actually take reasonable steps to keep secret. So let's then talk about trademarks. So trademarks relate to goods and services and marks related to goods and services. So trademarks can be things like a name of a business, a name of a company, slogans, it can be logos, and even things like colors or smells can potentially be trademarks, but that's kind of complicated in some ways. But the thing to understand about trademarks is they're intimately associated with goods and services. So where other sorts of intellectual property just relate to things generally, a trademark is going to be very associated with a specific type of good and service. So it really depends on what it is you're doing with the business, the products you're selling or the services you're providing. That really is going to be important when it comes to whether your trademark is protectable. A good example of that is Apple. So the first thing you're probably going to think of when you think of Apple is you're going to think of computer electronics, right? It's a company that does software that makes computers. But if you were to say have a company that was doing producing applesauce or producing apple trees, or selling apples, so that company couldn't trademark that name because that would be generic to that type of business. But it's important to note that multiple companies could have the name Apple. So there's Apple Recording Studios, which is actually the recording studio that the Beatles were associated with. So there can be multiple people who have the same trademark, but if they have different goods and services such that your average person wouldn't confuse the different companies, then maybe you can have the same mark, the same trademark for different businesses, even though there's though they're the same mark. As long as they're used for different goods and services, then people can have the same trademark. So I am a patent attorney. My focus is on patents, and patents relate to useful articles. So patents can relate to systems or things, physical products, or it can be methods of manufacturing something. It could be a method that is performed by, say, a computer or some software as it's performing its functions, or it can be things like methods of using things. Those are all protectable methods. So patents can be differentiated from copyrights as far as a type of intellectual property or IP. So patents relate to useful things or utilitarian things. Copyrights relate to artistic works. So a good example of copyrights would be things like paintings, a movie script, works of music, things like that. So they're definitely diametrically opposed, copyrights and patents. Again, patents cover utilitarian articles, copyrights cover artistic works. But that's not to say that things can't be covered by multiple types of intellectual property or IP. So in the beginning, when people are developing technology, it's probably going to be covered by trade secret. and then at some point when they patent it, at some point the patent, if it issues, or even when it's pending, a lot of times it'll publish and it'll become public. So the things that are in that, those things aren't going to be able to be trade secrets because they're publicly known, but they can be covered by patent. But there may be some aspects that are trade secrets. So if there's some processes that are software processes, say with with computers, if it's not known and you don't know what's going on in the back end, those could remain trade secrets. Whereas some functionalities could be patented. So you could have trade secret on things and you could have patents on things. Similar with copyright and patents. So let's say you have a chair. So because a chair is a utilitarian article, even though chairs are very artistic in a lot of ways, they are still utilitarian things. And so you would have to protect those with a patent and probably a design patent. But that doesn't mean that copyright isn't potentially applicable to that. So if you were to have a fabric design that was unique, that could be copyrightable. Or if there was a specific design or carving on something that was on the chair, that could be protected by copyright. So multiple types of intellectual property can protect a certain product. Just because something is protected by one thing doesn't mean it could be can't be protected by all sorts of other things. Like similar with trademark, for instance, if you have like the chair, for instance, if the chair is protected by a design patent, and then you have copyrights on the fabric design and maybe some carvings on it, you could have a copyright on that. But if there are brand names on it, or if there are things that really show that it's part of your company, like say Gucci, if you were to have Gucci on the fabric, that could be protected by trademark as well. So those are some things where there are multiple types of IP. And then as far as trade secret goes, if it's not easy to reverse engineer how something is manufactured, maybe there are trade secrets as to how the chair is manufactured. Maybe there are some trade secrets there that are also protected. So really, even a single article could be protected by the 4 types of intellectual property, which again are copyright, trademark, trade secret, and patent. So that's the definition of IP, or intellectual property. Hope you enjoyed the video. If you did, give it a thumbs up if you got some value out of it. And subscribe to the channel. This channel is all about giving you sort of the insider guide to how I help my clients be successful in protecting patents. So subscribe if you want more on patents and intellectual property. And thanks for watching. We will see you again in the next video.